Hello, and thank you for joining us today. My name is Yong Ki Hong, and I'm a senior associate at Scott Legal PC. Today's webinar will focus on E-2 visa investor requirements and renewal considerations. I will be covering the first general requirement section, and then our firm's another senior associate, Dustin Saldariaga, will take over for more specific considerations. Before we dive in, let me briefly introduce our firm and go over a few housekeeping items. We are a full-service immigration law firm. We offer services in a wide range of areas, including E2, O1, TN, L1, H1B, and any types of employment-based or family-based green card cases. We have processed hundreds of E2 visa cases. Many of them were higher risk cases and have worked with the US consular offices all over the world. One reason for this focus is that our firm was established on an E2 visa by our firm's founder, Ian Scott himself. That's why we know a lot about E2 visa world. At the end of the webinar, we'll send you several useful tools, a copy of a PowerPoint presentation we will go over through today, and a link where you can download the guidelines with more details on visa options, a link to sign up for additional webinars, and another link to webinar recording on YouTube. We encourage you to subscribe and hit the notification button as we regularly post immigration related videos. And another link where you can set up a consultation with us. Finally, for any questions, please type them into the chat box or Q&A box. We'll address all the questions at the end of the presentation. And with that, let's get started. So E2 visa. What are the requirements for the E2 visas? E2 visa is basically a great visa for entrepreneurs. You have to be a national of a treaty country, and currently the United States have signed a treaty agreement with more than 80 countries. The list of E2 countries occasionally change, not that often, but like every few years. A few countries would be added or fall off from the list. So you should check the official E2 country list before you actually submit your application. But keep in mind that you do not need to be born from the treaty country. You just need to hold a passport from that treaty country. So for example, you were born in India, which is not a treaty country with the United States, but later immigrant to Canada and have a Canada passport now, then you are eligible for the E2 visa. And then you must own at least 50%, half of the E2 company's ownership, and must be actively participating in the business operation. You cannot be just passive shareholder for the E2 visa. Next requirement is that you must make a substantial investment. And then what is the substantial investment? You will talk about more details later, but generally speaking, it means the sufficient amount to make E2 business fully operational. The fund must be at risk. This means you actually need to spend money. You cannot claim an investment when your wire transfers the fund are just sitting in your E2 business corporate bank account. The fund must be used before you submit the application. Then how much investment is enough? Well, we'll discuss more details later of this presentation, but generally speaking, the question you should ask is what kind of business you are starting and what are the reasonable startup costs for the type of business. If it is $50,000, then $50,000 will be enough for your business. You also need to prove that investment funds are coming from the legit source. For example, if your funds are from a sale of a property, then you will need to submit a signed contract, a closing document for the transaction, and make bank statement showing the deposit of net proceed from the transaction. For this matter, please keep in mind that government want to see very clear fund flows from the documentation. So you should really try hard to keep the documentation, keep it simple and easy for the government officers to understand how the funds are originated and came to E2 business account. Business also must be real and operating. What it means is that when you arrive at United States with a valid E2 visa, your business must be able to start operating. To prove this element is satisfied, you will usually need to submit a signed commercial lease. Business entity has in the documentation prove that the business entity has been already established and registered. And another proof maybe a company website is already up and running. Contracts with the other customers or vendors. Those documentation will prove that your business E2 business is already set up and ready to operate as soon as you come to United States. There's also a marginality requirement. The whole point of the E2 business is just creating jobs and contributing to the local economy in the United States. And that's why U.S. government want to give you E2 visa. Please spend the money and hire U.S. workers once you fully establish your E2 visa. So if E2 visa is barely making income just to cover you and your family members' living costs in the United States, then government would not like it because you are not really providing contribution to the local economy. Therefore, it is very important that your E2 business should create enough incomes to hire US employees. You can even hire an employee before you apply for the E2 business. Such would actually strengthen your E2 case. And E2 visa also requires you to have an intent to return to your home country upon expiration of your E2 visa. Basically, E2 visa is not a green card or does not automatically lead to a green card. It only allows you to enter United States for temporary period to develop and run your E2 business. But it does not mean you cannot renew your E2 visa or obtain US permanent residency. You could do it. You could renew it and eventually go after US permanent residency, but you should carefully design your case direction with the immigration attorney for the green card application. And let's move to the next slide. So there are two options to approach your E2 visa case. One is to start your own business, and second is purchasing an existing business. The first option is basically you need to do everything from the scratch. You have to register your corporation in the state corporation department. You need to sign the lease agreement. You need to do many things to have your business up and running. Second option is to buy just existing business. Buying existing business also has two sub categories approaches. The first one is you can go through the sale before your E2 visa is approved, which will be a little more riskier option because you already own the business after end of a transaction, but you are not even authorized to run the business yet because you haven't submitted your E2 visa application yet. So somebody else in the United States need to run the business for you while you are going through the visa application. Another option for buying an existing business is going through the escrow agreement. This means all the terms and conditions are satisfied in the transaction except for the visa application, visa approval. So escrow agent will hold the whole money in their account, and once he confirms that your E-2 visa is approved, then he will release that fund to the seller. However, the E-2 visa application is denied, then money will go back to buyer, you. So it gives you more protection, and therefore it is more attractive option than first one. Next one, how long is the visa, E-2 visa valid? It depends on the treaty agreement between the United States and the foreign country. It could be very short, like 3 months, or it could be 5 years. It does not mean that you cannot run the business. You could run only business 3 months based on your visa validity duration. Even if your E-2 visa is only three months on your passport, you could run more than that. Regardless of visa validity duration, you will typically get 2 years of E-2 status when you come to the United States. So you could run your E-2 business for 2 years, but once you go out from the United States, you have to reapply and renew your E-2 visa again. So please make sure to understand the difference between visa and status. A visa is more like an admission ticket to the United States. But once you are inside the United States, your authorized duration of stay not governed by the visa. The CBP's I-94 form will decide your actual duration of stay. And for the E-2 visa, CBP officers usually give you only 2 years of duration of stay every time you enter the United States, which means even if you have 5 years of E-2 visa on your passport, you may need to make international travels at least a couple of times to renew your I-94 durations. So it is very important to check your I-94 status every time you re-enter the United States. And with that in mind, let me turn it over to Dustin, who will guide you through the next part of our presentation. He will cover how to build up and improve your E-2 visa case. So please stay tuned.
Perfect. So thank you very much, Yanki, and thank you all for joining us. I know someone has raised their hand. If you do have a question, send it in through either the chat or the Q&A box due to the functionality of our webinars. Okay, so one of the most common questions that we get about the E-2 visa is how much do you need to invest? The E-2 visa does not have a defined dollar amount requirement. It's not like, for example, the EB-5 green card, where there is a very specific dollar amount that you must invest. Rather, for the E-2 visa, as Yanki said, the question is how much you need to spend on the business to make it operational. So that can change depending on what type of business you're starting. If you're starting a small law firm, then it could only require less than $100,000. If you're starting a manufacturing company that's going to manufacture electric vehicle batteries, for example, you're obviously going to need to invest a lot more to get that business operational. So that really is the question that the government is going to ask is, okay, you are saying that you're going to start an E-2 business that does this thing or provides this product or service. How much does that business require to get started? And have you spent those funds to get it started? That's the first question. Now, there is a second question, which is, even if your business does not require a lot of money to get started, the consulate or USCIS is still going to want to see that you've invested a substantial amount. So let's say you are starting a small law firm, and let's say that you can start that law firm with a laptop computer and a few subscriptions, and malpractice insurance, and that gets you to about $15,000. $15,000 is still not going to be enough, even if it's sufficient for your business. So in that case, we do recommend that you try to invest ideally at least $100,000. That tends to be what consulates look for. But that being said, it is certainly possible to be approved if you have a lower investment amount. And we define a lower investment amount as under $100,000. We have had clients be approved with investment amounts in the $40,000 range. That being said, you do have to strengthen the application in other areas. So you need to focus on hiring US workers, showing that you have executed contracts, things like that. So if you have invested, say, $40,000, but you already have clients and you're already employing US workers, then the investment amount becomes less important because you've already shown the government that even with a low investment amount, you have already created jobs for US workers. So you can see how the investment amount, it is kind of flexible, but does depend on convincing the government that you'll employ US workers. It also is relevant where you apply. USCIS tends to be less strict about the investment amount. They tend to be accepting of lower investment amounts than consulates in general. And certain consulates are more strict. So consulates that tend to see a lot of E-2 applications, particularly from large companies, tend to expect a higher investment amount. And consulates that see typically startups or fewer E-2 applications may expect a lower investment amount. And we, of course, help guide our clients through that process. So what is the proportionality test that you see on your screen? Really, what this means is for a business that is lower cost, so a law firm, the government's going to want to see 100% of the funds needed for that business invested. Whereas a business that is more expensive, say that manufacturing company, the government will accept a lower percentage. But typically it's if you're starting a $10 million business, they might accept 80% of that invested. For practical purposes, I wouldn't, unless you're starting a very expensive company, I wouldn't even think about the proportionality test. I would just invest the funds that are needed to make your business operational. Now, you do have the option of buying a business. So if you are buying a business, what is a substantial investment amount? Really, it is the fair market value of the business. So let's say you found a convenience store that's for sale. You really just need to show the government that that convenience store was on sale on the open market and you paid the fair market value for it. If you're buying from a friend or a family member and they're giving you a significant discount, that could be a problem because the government may say that's not a substantial amount. So do pay the fair market value for the business. Franchises can be a great option because it's a combination of a startup and kind of an existing business. Franchises give you a lot of support. They'll oftentimes help you find a space, give you the software, give you access to clients, and obviously a recognizable name. So franchises can be a wonderful option for an E-2 visa. And they also oftentimes will list out what their costs are, how much is expected for marketing, how much is expected for the software, etc. So you would show that you've paid those expenses, that they're common for this franchise, and that's typically fine for E-2 purposes. And finally, there are good E-2 expenditures and there are bad E-2 expenditures. So good expenditures are in general anything that's needed for the business to be operational. The most common categories are inventory, payments to employees, equipment like computers, furniture, office supplies, licenses that the business needs. If you're operating a restaurant, you need a license from the health department. So paying for that is a great expense. Relatively bad E-2 expenses are expenses that don't clearly benefit the business. So for example, if you are traveling to the US to sign the commercial lease, don't include your travel expenses. Don't include your hotel expenses. Those are weak expenses. And if you put them in, then the officer is going to think you are inflating your expenses and it casts doubt on the application. So better to leave that out. Also, educational expenses. If you're starting a law firm, don't include the tuition for your law degree. That's not going to be counted. So Typically, education expenses, training expenses are not good E-2 expenses, with certain exceptions that we can talk about in the question and answer session. So, do I need to hire US employees? Another very common question we get about E-2 visas. The answer is that you do have to hire US employees, but not necessarily before you apply. So, fundamental to the E-2 visa is that your business needs to create jobs for US workers. If you fail to convince the consular officer or the USCIS officer that your business is likely to employ US workers, you are almost certainly going to be denied. On the other hand, if you convince the officer that your business will employ US workers or already does employ US workers, then you can overcome other weaknesses in the application. As I mentioned before, for example, if you have a low investment amount, but you're already employing US workers, that can strengthen your application and cause the officer to say, this case should be approved, even though the investment amount is low. So employing US workers really is a make or break aspect of the application. So how many workers are we talking about? Typically, what we recommend is you need to convince the government that the business will employ at least 3 full-time equivalent US workers within 5 years of the business starting operations. So again, you don't need to have those employees before you apply. But if you don't have those employees, then you should include a business plan that clearly shows how the business is going to get to that point within a 5-year time horizon. So, common question that we get as well is, do workers include independent contractors? So in the US, we have basically workers fall into 2 categories. If you're performing work, you're either a W-2 employee. That means you are on the company's payroll. You have typically certain benefits, certain rights as an employee. That is preferred to independent contractors who really are in business for themselves. So, for example, if you are having work done on your house and you hire someone to build, something at your house, that's typically an independent contractor. They have their own business. They will show up when they want to. They will leave when they want to. As long as they get the work done at the end of the project period, they get paid. An employee is the kind of worker that shows up at 8 a.m., leaves at 5 p.m., has health insurance, things like that. So the government likes to see W-2 employees, and that is ideal. So ideally, employ at least 3 full-time equivalent US employees within 5 years. A little bit weaker is part-time W-2 employees. They're still very beneficial. And if you use part-time employees, remember that 6 part-time employees is the equivalent of 3 full-time employees, so that you can meet the requirement through part-time employees. Weaker though than W-2 employees is independent contractors. And so if you're going to rely on independent contractors, I would say it's important that your industry typically use contractors. So don't use contractors, don't rely on contractors if it's not common in your industry. So if your business is, say, a construction business, and it's very common to use independent contractors, it's okay to say, you know what, I'm going to have 10, 20 independent contractors performing these services. You do want more than 3 to 5 workers. You want to show us a more significant number. You also want to show that they will be consistent independent contractors, that you're generating regular work for these contractors. Now, another thing to keep in mind is it is fine to start with independent contractors and convert them to employees. So in your business plan, you might say in year 1, I'm going to have 1 independent contractor and it's going to be a marketing person. I'm going to hire them. They're going to build my website. They're going to do all my marketing. And in year 2, I'm going to convert that person to a part-time W-2 employee who's doing marketing. And by year 3, I'm going to convert them to a full-time employee. So again, we're showing how over the course of time, you're going to have 3 full-time equivalent US workers within 5 years. And it's fine in the early years to show that transformation, that you're taking steps to get there. And the final note I'll say on employment is, or on the employee piece is, that you it is better to start employing people early in the process. So even though the government has a 5-year time horizon, the earlier you can start employing people, the better. So how do you prove employment? I already mentioned the business plan. Business plan is critical if you're not already meeting that employment requirement. Also, letters of intent. These are letters from prospective clients, and that shows that there's real demand for your products and services. So including those letters shows that your business is likely to generate revenue and likely to need workers to provide those products and services. For an existing business, so if you're buying a business, you would include W-2 forms, which is the tax form showing payments to employees, pay stubs, and tax returns, proving that the business already has those employees. And in a very important note, if you are buying a business, really try to get buy a business that already has 3 full-time equivalent US workers. Because if you don't, if you buy a business, for example, that has 1 employee or that has an employee and then the owners have been working, owners don't count as employees. But if they only have 1 employee, you are starting from a defensive position where you have to explain to the government why the business hasn't already met these figures, and it's creating a hurdle for yourself to overcome. So rather than doing that, look for a business that already has 3 full-time equivalent workers, and it's easy to show then that you're already meeting that requirement. All right, so we talked about the business plan. Um, what does a business plan need to include? So our firm does prepare business plans. One thing that I would say is special about using our firm for a business plan is that we have the consular officer or USCIS in mind as our audience. Many companies that prepare business plans don't have that intended audience. They're looking at potential investors or potential funding sources as their audience for the business plan. Whereas we frame our business plans really for immigration officers. So we try to put front and center the things that immigration officers care about most. So that being said, you can prepare your own business plan. You can use a third party. The government will accept those business plans, but they should include certain things. So the executive summary is really critical. That is usually a page, maybe 2 pages at the front of the business plan. It's almost like an elevator pitch: who you are, what the company is going to sell, um, who they're going to sell to, how much you're going to sell your products for, really high level, how much revenue you expect to generate, how many employees you plan to employ within 5 years. Really just, if the government officer, is going to spend 30 seconds with your business plan, you want them to get that information. And to be honest with you, most officers are at most going to read the executive summary. Many of them don't get past the executive summary. So you do want to make sure you have everything in that executive summary that you want the officer to know about your business. The business plan should also have a market analysis and research. Even if the officer isn't going to get to these pieces, it's important to have them just in case. And also at your interview, questions might come up where you want to flip to these parts. So market analysis and research, really showing who your competitors are, who your target market is, why you think you are going to have enough customers to sell to. A marketing plan, how you're going to get customers and how you're going to keep them. A personnel plan. This is critical because the personnel plan is really showing exactly how many employees you think you're going to employ in year 1, 2, 3, 4, and 5. And the business plan, to be clear, should be a 5-year projection. Why 5 years? Because that's the maximum period of time that an E-2 visa can be issued for. And finally, a comprehensive business financial plan. So that is showing over the course of 5 years, profit and loss projections, balance sheet projections, so assets, liabilities, and net worth, and cash flow. So you want to provide all those details to the officer. So let's talk about a few E-2 visa considerations. So We file E-2 applications around the world and within the US. If you're filing within the US, meaning not at a consulate, then you're filing with US Citizenship and Immigration Services, or USCIS. Um, so there are a few things to be mindful of. Um, First of all, if you're outside the US, then your only option is to apply at a consulate. And as of now, your only option is to apply at a consulate where you are a resident of or a national of that country. So um, the Department of State has restricted who can apply to consulates as what are called third country nationals, meaning people who don't have ties to the country where the consulate is. So right now, you should apply in the country where you are a resident or you have nationality, meaning a passport from that country. If you're inside the US, though, you do have the option of applying either at a consulate or within the US through USCIS. So when would you choose each? Generally speaking, we recommend applying at a consulate, and the reason is that you get a visa. When you get a visa, you can come into and out of the US. Um, Contrast that to USCIS. If you apply within the US, what you're applying for is status, and status is not a visa. So if you're inside the US and you apply for E-2 status and you're approved, the moment you leave the US, you lose your E-2 status. Okay. And you then have to go to a consulate to get the visa. So a consulate is great because you get a visa and you can enter and exit the US. But for some people, USCIS does make sense. Let's say that they have no plans to travel and they're already in the US. Then USCIS could be a good idea. And during COVID, when the pandemic was very active, um, people couldn't travel. So airports were being shut down, borders were being shut down. So USCIS filings increased. We are also seeing an increase in the USCIS filings now because people do want the security, if they're already here, of knowing, okay, I have status and I can work on my business while I'm in the US. They might do that while they have a consular application pending. So they'll start working within the US after being approved through USCIS. And then when the consulate is ready for them to interview, they'll fly to the consulate and get their visa. Uh, One thing to note is USCIS does offer premium processing, which will get you a decision within 15 business days. That can be a very helpful option if you really want to get started now on the business as soon as possible. So you do have to wait for that decision, so 15 business days. But compared to consulates, that is going to be your fastest option. I don't think there's a consulate in the world that is that fast. Um, Consulates, on the other hand, are typically taking about 3 months between the date of filing to the date of the interview and issuing your visa. So do keep that in mind in terms of timing. A few other things to keep in mind. USCIS tends to be more accepting of lower investment amounts. So if you do have limited funds to invest in the business, USCIS could be a good option. On the other hand, USCIS is very particular about your source of funds. So if you apply with USCIS, you need to be ready to document every single dollar you have invested in the business and the exact path that every single dollar took from the source, whether that's inheritance, selling an apartment, working for 10 years, whatever it is, documenting that dollar from the source all the way to the E-2 company. Consulates tend to have page limits. Not all of them, but many of them have page limits. So you can't actually document every step that that each dollar has taken. So consulates tend to be more accepting if you have limited documentation on your source of funds. That being said, you should be ready to document every step that your dollar has taken. With consulates, you can typically submit a more streamlined application, and oftentimes the consulate will not require more, whereas USCIS will. Um, so we talked about source and trail of funds. Loans secured by company assets. So one of the good things about the E-2 visa is that the government is very flexible and open about your source of funds. You can use gifts from people as long as you can prove where that person got the gift. You can use almost any legal source of funds. with a few exceptions. One of the exceptions is you cannot use a loan that is secured by your E2 company's assets. You can use a loan that's secured by your personal assets. So if you have a home and you use a HELOC, a loan on your house, you can use that as your E2 funds. Um, but if you have your E2 company in the US and you take out a loan that's secured by the E2 company, that is not going to be accepted by the government. So be aware of that. One way to use company, let me quickly say another source of funds that's not accepted is retained earnings in the US in the E2 company. So let's say you already have an active company. Maybe you started it remotely from abroad. Maybe you started it, say, as a student. You had OPT and you started a business and it's doing well. And you have retained earnings in that business. You would first need to distribute those earnings to yourself, pay taxes on them, then reinvest those funds into the business because the investment does need to be your personal funds. Um, so keep that in mind. But generally speaking, loans, again, secured by your personal assets are fine. Gifts are fine as long as you can document where they are from. Some considerations for small investment amounts. We already touched on this, but it's good to include in your application letters of intent from customers and clients who plan, prospective customers and clients who plan to do business with you. Also, you can get a letter from a certified public accountant talking about how your investment amount is sufficient for the type of business you're starting, and the CPA would sign that based on their experience. So there are a number of things you can do to boost your chances of approval with a low investment amount or a small business. Our firm, just to quickly note, is proof of that. So our firm was started on an E2 visa with a quite low investment amount. And our firm has been active for about 11 years now. So we are proof that it's possible to be approved, and we regularly work with clients who have lower investment amounts. E2 visas for two investors. So the requirement is that each E2 investor needs to own at least 50% of the E2 company. So that means you can have two E2 investors. They each just need to own exactly 50% of the business. We handle these applications all the time. One of the interesting things about this is if the two investors are from different E2 countries. So let's say one investor is from Canada, has a Canadian passport, and the other one is from Germany, has a German passport. That E2 company will have dual nationality, meaning that it can hire E2 employees from either country. So the employees would need to qualify for an E2 employee visa, but you could have employees from Germany and Canada coming to the US working for that company, which is an interesting aspect. Next, substantive changes to the business after filing. This can be tricky. And what this means is, let's say you start an E2 company that's a restaurant, and you get into doing computer networks, like installing the internet and advising businesses on the internet. You, in general, if your E2 application was based on a restaurant, you cannot then start your internet business while you're in the US on an E2 visa. However, if you started a restaurant and you now want to open a coffee shop, that's probably fine because it's similar to the E2 business. So the first thing you have to do in this scenario is look at the scope of your approval. What did you tell the government that your business is going to do? If you said, I'm going to open a restaurant and now I want to open a coffee shop, those are related. You're still selling food and drink at your E2 company. That's probably fine. But if you told the government, I want to start a restaurant and now I want to get into installing networks, internet for companies and clients, that's going to be a problem. The exception is if you actually define that in your scope. So if you're in your application, you said, I'm going to start a restaurant, but I also want to start as part of my business, I'm going to do internet installation. That's probably fine if the government approved that. So if you think that your business might get into another aspect, put that in the application, put it in the business plan. And that establishes the scope and it gives you a lot more flexibility once you get into the US to actually start working on that thing. Now, if you didn't do that and you want to expand into something new, what you would need to do is ask USCIS to amend your approval. And that is a whole process. We have filed that request for approval for clients before. It's not particularly complicated, but there are times when uh, you may need actually to submit a new application for an E-2 visa if the nature of your business really has changed. So this is an area where you should talk with a qualified immigration lawyer. It can get complicated. It is a gray area. What is a substantive change? What is not a substantive change? We'd be happy to help with that. Finally, a few higher risk cases. There are certain types of businesses that are just higher risk. And in general, those are businesses where the government does not see that the business needs employees. As an example, real estate and equity trading. So trading stocks, for example. If you're starting a real estate investment company or you're starting a stock trading company or an investment company, the government will oftentimes assume from the start that you don't need employees. So you are creating a hurdle that you need to overcome by entering these fields. That being said, you can certainly get approved for these. You just have to make it very clear in your application that your business is actually going to require employees. So, for example, in real estate, if you're not doing real estate investment and instead you are doing construction or you are flipping homes in the dozens of homes, not just a home or two where you don't really need many employees, but you're working on a dozen or more homes, you can show we are going to need employees for this business. So that is critical. Show that your business actually needs employees and you can overcome the risk that's innate to these types of applications. Finally, family business purchases. I mentioned this before, but if you're purchasing a business from a family member, it is really important that you make clear you're paying the fair market value for the business. You cannot get a preferential price because if you do, the government may say you didn't invest a substantial amount in the business and you may be denied. So make it clear that the amount you're paying actually is the fair market value. You may need to hire an accountant to actually value the company and say you're paying the fair market value, but or you may just show that your family member advertised the business to the open market for the price that you're paying. But do prepare to explain to the government that you're paying the fair market value. All right, some common reasons for E-2 denials. We've already touched on a number of these. A low investment amount is a common reason for a denial, especially if the funds have not been spent. So as Yankee said, it's not enough to just transfer funds to an E-2 bank account, the E-2 company's bank account. You actually need to spend them. They need to be committed to the business. So make sure you've invested a substantial amount and you've actually spent funds on the business to make it operational. The question that I tell my clients to have in mind is when you are at the consulate, imagine that the officer says to you, if I give you this visa, are you ready to fly to the United States tomorrow and start operations? You need to be able to say yes, meaning you need to be able to show them, I have a space for the business, I have the equipment, I have the inventory, I just need to show up and start running the business. The nature of the business is also a common reason for a denial. Again, if you have a real estate investment company and you don't make it clear that you're going to employ or need US workers, that's a likely denial. Same with an investment or an equity company. The filing location or the venue, there are certain consulates that are just very, very difficult. And as we mentioned before, certain locations are looking for certain things. So USCIS is looking for a clear source of funds with complete documentation. So if you fail to provide that, you're looking at a likely denial. And we do help our clients navigate what their filing location options might be. Just as an example, clients may have dual nationality in two E2 countries. They might be in the US and have the option of applying at a consulate or USCIS, and we'll help them navigate that and look at the pros and cons of each option. Another common reason for a denial is if you have a business in your home country that provides the service that the E-2 business will provide, but you have not employed workers in your home country. So to take an example, let's say you run a consulting company in Canada and you want to start a very similar consulting company in the US. But in Canada, you've been operating this business for 5 years and it's only you and your spouse who work there. That's a problem because the government is going to say, okay, so you are going to start the same company, same type of company in the US, and you're telling me you're going to employ workers where you haven't employed any workers over 5 years of doing this. So what you'll need to do is overcome that in your application. Point to very specific things you're going to do differently in the US that's going to lead to employment in the US, whereas it didn't lead to employment abroad. Maybe you're providing a different product or service. Maybe you are changing your marketing approach, but you need to anticipate that scrutiny in your application. If you don't, there's a good chance you'll face a denial because again, the government won't be convinced that you'll employ US workers. Next, issues with the adjudicating officer. Unfortunately, um, these applications come down to the officer's discretion. At a consulate, even if the officer is just denying based on them having a bad day, that is an acceptable basis for a denial, unfortunately. Most of the time, we do find that consular officers are well trained and they do have the best of intentions. And if you do have a viable application, it will be approved. That's what we typically see. But there are times when you just get an officer who's not well trained or an officer who just is adversarial and just angry. Or whatever is going on with the officer that day, and it could lead to a denial. The good thing, though, is you can reapply, and typically the officer will explain the basis for the denial. So you can go back, you can address the weakness that the officer found, and apply again in most cases. Um, a USCIS denial is different. Typically, USCIS has a higher bar to deny because you can challenge a USCIS denial, whereas you cannot challenge a consular denial. So USCIS knows that, so they tend to really look at applications more closely than consulates tend to, especially if they're going to deny. They will typically have a good basis for a denial if it's USCIS. And finally, sometimes applicants just do not meet the requirements at the time of filing. Sometimes people will come to us after having been denied and we'll look and say, well, you don't own 50% of the business, or all of your investment is just sitting in the bank account. You haven't spent anything. Clearly, they haven't met the requirements. So do make sure you meet the requirements. What does it take to renew an E-2 visa? So hire workers. As we've said, it's key. Show that you are employing workers. You want to include W-2 forms. You want to include tax records, payroll records, showing that you're hiring and employing US workers. If the company's not doing well, do your best to boost hiring, even if it's soon before you're applying to renew. Show that you have people on the payroll. Does the company still meet the E-2 requirements? Make sure you always maintain that 50% ownership share. If you sell equity, you have to always keep 50%. As soon as your ownership share drops below 50%, you become ineligible for the E-2 and you have to leave immediately. So that's really critical. Also, changes to the type of business, as we mentioned before. Keep your business aligned with the scope you told the government the business would pursue. If you change the business, get into a new area, be very careful. Talk to a lawyer before you do that. And if you have to notify USCIS or the consulate, do that. And finally, developments and adjudication trends. So many people ask, under the current administration, are we seeing changes? Not a ton. To be honest, we do regularly still have high approval rates. The government's published rates are in the 80 to 90% range. So that is fairly high. Our firm has a very high approval rate, although past performance doesn't predict or guarantee future outcomes. We do see, though, that the government does want to see the bulk of the investment being spent in the US. So what that means is if you are spending $100,000 on starting a retail business where you're going to sell goods, and 80%, $80,000 of that amount is going toward buying inventory from China, that could be a problem. So try to make sure that at least half of your investment amount is being spent in the US. Hiring of US citizens. So this is usually not an issue in the E-2 space because one of the requirements for an E-2 visa is employing US workers, creating jobs for US workers. But it is still good to emphasize that in the application, that's what your business is going to do, especially if you're hiring an E-2 employee. It's important for that application to explain why an E-2 employee is needed, whereas a US worker either is not available or is not appropriate. Again, focus on employees rather than contractors. And you can be approved with contractors, but it's a weaker application. Having employees definitely is the stronger option. Administrative processing. This is a really unfortunate thing that consulates do now. Sometimes after going through the interview, consulates will then pass the application on for security screening, what's called administrative processing. There are different levels of this. Sometimes it's at the consulate and can be a quite fast review. Sometimes they send the application to the FBI, the CIA within the US, and it can take months. And unfortunately, it is a black box. You have no idea what's going on. You cannot find out what's going on. You really just need to wait. And you can ask the consulate, you can follow up and ask for updates. But this is an area where you just have to wait if your application is put in administrative processing. As I mentioned before, we are seeing more USCIS filings, though consulates are still preferred, I would say, because you do get a visa in general. In general, they're preferred. You are, though, seeing longer waits at consulates. Nowhere near what we were seeing during the COVID pandemic, but still in the 3 to 6 month range, I would say, from applying to getting your interview. All right, so we can turn to questions. I know a number of questions have come through. So Yankee, do you want to read through these or do you want me to just dive in? I know we're a little short on time.
Okay, just one thing that you should know is that we received some questions before today's webinar. Those are very valuable questions, but I think that participant post the same questions in the Q&A box. So
Right.
yeah, so you can just go ahead and answer those
Sure.
questions in the Q&A box. Yes.
Perfect. Okay. So first question regarding the investment being at risk. Are there some supplies that there are some supplies I cannot find in the US and would like to purchase them from Europe. Is this purchase acceptable? So yes, it's acceptable again, as long as the majority of your investment is being spent inside the US. So do try to limit your purchases outside the US to 50% of your total investment amount. Business partner. I do not have a business partner. I plan to apply by myself and then look for a business partner in the US. Is that a problem? That's not a problem as long as you maintain 50% ownership of the business. So it's fine if you apply as a 100% owner, enter the US, and someone wants to buy half of your company. That is fine. You just have to keep 50% of your business. Consultation fees. Would the other note I will say on that business partner piece is don't use that as a way to get around the investment requirement. So let's say that you have a low investment amount as a 100% owner, and as soon as you get into the US, you sell half of the business for half of the investment amount. That's generally fine, but it needs to be a legitimate sale of the business to the co-owner. Like don't use it as a way to avoid the investment amount or to recoup your investment. Consultation fees. Are fees spent on a consultation with your firm considered money put at risk? Legal fees for the E-2 visa are considered an acceptable E-2 expense. They're not a strong expense. They're not as strong as showing you're paying employees or you're buying inventory, but we do tend to include them on the investment schedule for these applications. I plan to work out of an office in a rented house. Would the rental costs be considered at risk? It's not commercial. I would advise against this. Get a commercial space, even if it is just a dedicated desk at a co-working space. The government, if they find out that you are renting out a residential space, they can scrutinize that and discount it. So best to avoid that complication. Training. Could I do training to be able to run my business better? You can. Uh, so you can do the training, but I think the question is whether that would count toward your investment, and the answer is probably not. The example I gave before is if you're starting a law firm, you can't include your law firm tuition, your law school tuition. Um, the exception is if the training is specifically needed for the business. So, for example, if you're starting a restaurant in a state and that state requires that you, as the owner, be trained on health issues, you can include that training because it's really specific to the business. But if your training is investing in yourself as a professional, I would not recommend including that expenditure. So the what would happen to the business and the employees after I decide to go back to my country and not renew the E-2 visa? That's not really an immigration question. It's more what you end up doing with the business. From an immigration perspective, if you abandon your visa and leave, you're done from an immigration standpoint. Immigration only applies to what you do when you're inside the US. So if you want to wrap up your business, you can sell it. You can just terminate it and fire your employees. It's not really an immigration question. Are we in partnership with accountants? Our firm does have a CPA, but that is largely within the context of preparing business plans. So if you do need accounting services, we would recommend you reach out to an accounting firm. We don't provide accounting services as an accounting firm. Do we draft client contracts, subcontracting agreements? No, not in general. We do have templates, and we're happy to provide those to you. But if you are looking to draft contracts, it is typically best to get a business firm to draft those or a contract firm to draft those. Our firm is an immigration firm, and so we look at visa compliance and preparation. During a visitor business visa, can I convert prospects into clients during a pre-launch event held in the US by having them sign contracts while I'm in the US? I think that's risky. So the B1 visa is for approved business activities, and you can find online what the government considers to be acceptable B1 business activities. Going to conferences is fine. Signing a commercial lease is fine. Opening a commercial bank account is fine. Meeting with clients and signing contracts looks a lot like engaging in work and generating revenue for your business. So I would advise against that. I think that is risky. But that is a gray area. And if you want to talk about it further, do schedule a consultation. With the fact that I'm organizing and paying for a pre-launch event at a hotel with conference rooms be a problem? If you're outside the US, it's perfectly fine. So you can hire someone in the US to execute those contracts. And that is actually a wonderful thing to do because you're outside the US. You are not going to be accused of violating your work authorization or lack thereof. And you're hiring a contractor or an employee. So that could be a wonderful way to do this. And yes, the expenses can be included in your marketing expenses. Professional membership, similar to what I said before. If the professional membership is more for the business and less as an investment in yourself as a professional, it can be included. If it is an investment in yourself, I would not include it. What are the payment methods to pay for your services? We have a variety. Reach out to us if you'd like an engagement letter and schedule a consultation. We'd be happy to share that information with you. We'll send an email after the presentation with more information. I have tax paid personal in I've paid tax on personal income from okay. I think what the question is asking, I've received income from a business in my home country. You can certainly use that as your investment amount. The issue is when you're using retained earnings of your US business, the E-2 business, and that you must distribute those funds to yourself, pay taxes, and then invest them. I'm not sure I understand the question about pick and drop rides company. In general, if you create jobs for US workers, the nature of the business is not as important. As long as it's not doing something the government prohibits, like a common example is hemp or marijuana. You don't want to do a business based on that. Can I lease a warehouse in the US without a letter and apply for the E-2 visa during I'm sorry, I don't understand that question. You can lease, I'll just answer it in general. You can lease an office space in the US, a commercial office space. You can come to the US on a B1 visa to sign the lease. You can have someone in the US sign the lease. That's fine to execute a commercial lease. Can we change status later? And then later do consular processing. Yes, many people who are in the US, if they want to start the E-2 company, they'll apply for a change of status in the US at the same time that they file a visa application at a consulate. And then when the consulate is ready for the interview, they will go to the consulate for the visa. And they would have already been approved. If they've been approved for the change of status, they could be approved within 15 business days and start working on the business while they're waiting for the consulate. So that can be a great option. Perfect. So we are right at time. Those were great questions. Yankee, thank you so much for the great information. Thank you to our audience members for the wonderful questions and participation. Keep an eye out for the email for more information and where to schedule a consultation. And we do hope to hear from you soon.
Thank you.